Hi, I'm attorney Jason T. Brown, the head of the law firm Brown LLC, and I'm here today to talk to you about how to file a PPP loan fraud whistleblower case. The PPP was a program known as the Paycheck Protection Program. It was rolled out in the time of COVID, and the government right now is first getting around to looking into all the extensive fraud that occurred with the PPP program. Even though the PPP was designed and purpose for monies to flow to the employer and in turn to flow to the employee, certain unscrupulous employers instead used the funds exclusively for themselves. And there's even cases about the PPP being for Pokemon cards, Porsches, and planes. And the employees got nothing. So that's exact opposite of what was contemplated. Billions of dollars went into the PPP program, and it's estimated that actually there's billions of dollars of fraud in the PPP program. So individuals from the inside who have information, who blow the whistle the right way using a False Claims Act law firm may be eligible to receive whistleblower awards up to 30%. I predict in the years to come, tens of millions, if not hundreds of millions of dollars will go to whistleblowers who unearth massive scandals for companies that took PPP loan funds in the wrong way. So let's get into what's actually viable and what's actionable. But by talking about that, let's first talk about what's not viable. There is a lot of people that call our office saying, my employer just didn't need the money. Well, if that's the case, that is not enough to proceed. There was fiscal uncertainty for the first line of PPP loans for round number one. And all an employer had to certify was that the fiscal uncertainty made it a necessity for them to have the loan so they can continue to pay the employees. And as long as that money ultimately flowed to the employees, even if the company failed to properly segregate it, we don't think that's enough for a PPP loan for a whistleblower case. In fact, we think that's exactly what the loan was for, to flow to the individuals. However, for the second loan, the second round of loans, if in fact the company received a loan, they had to certify that they had one fiscal quarter that was inferior to the year before. If that occurred, then potentially and most likely, if they falsely certified that they had a bad quarter when in fact they didn't, then the second round loan may be actionable for the company not needing the loan. Our targeted type of case that we think is going to be the most actionable, and not just actionable, but collectible and not criminal, and we'll get into that in a little bit, has to do with deflation. And what I mean by deflation is for companies that deflated their census and or headcount and deflated their revenue that they were claiming for the payroll. So under the first round of PPP loans, companies had to have less than 500 employees for the most part. There are some exceptions, and less than 10 million in loans that they were requesting or eligibility for. And what went on is certain companies falsified payroll and deflated payroll and deflated their employee census count to claim that they were individually below those caps in order to get loans that they were not eligible for. Now, we think that that's highly actionable if you have the goods as an insider about that type of information, and it's probably collectible and compared to a lot of other different fact patterns. One of the other things about it is the government/taxpayer was concerned about the interrelativity of different companies, common nucleus of ownership of different companies. So if company one only had 400 employees and company two was an alter ego of company number one, and it had 700 employees, and combined they had 1,100 employees, and they put in for just 500 combined, that may be actionable. So not to do fuzzy math as a lawyer, but if there was a common nucleus of ownership of various companies who in aggregate for the first round of loans exceeded 500 employees when you combine the census of the two populations, or in aggregate busted through the 10 million, that may be actionable. We like to look at cases in which companies maxed out the PPP or got close to it, but in fact concealed that common nucleus of ownership and potentially committed violations in their certification by not disclosing the different interrelated companies. So there's the deflation. This opposite side of that is actually inflation. Inflation cases involve when employers falsely aggrandize the amount of employees they had and aggrandize their payroll in order to obtain more from the federal government and the taxpayer. That will be easily demonstrable because companies are required to file their quarterly information with the IRS. Insiders should have information if a company's falsely claiming that they had 50 employees when in fact they only had 10, that's just an outright fraud. That's an outright false certification, or like the statutes say, a false claims for the False Claims Act. Where there's a will, there's a way. There's many different ways that companies have gamed the system. I told you earlier we're going to talk about criminality and collectability. Well, some of the concerns we have as a law firm is we like to help. We do pro bono work at times. We like to help individuals. We like to help the system by getting taxpayer money back when the taxpayers have been defrauded. However, some of these just are not going to be collectible. From our perspective, if it's a low dollar loan, like $50,000 to $100,000, probably even lower than $1 million, our firm most likely will not take the case. It's going to be hard to collect those matters. If these are one-time individuals that receive that amount of money, they probably already blew through it and they're not going to be able to collect at the end of the day. Further, there's some criminal consequence to conduct. So there are certain companies that just bust it out. And what I mean by that is we're suing one. It's a public record out in California. We sued a company. They took millions and millions of dollars in COVID-related relief from the PPP, other restaurant-related type of bailouts, EIDL loans, EDIL type of loans, and other SBA loans. And after they received the money, they just jumped ship and ran. They didn't send any of that money to the employees. They falsely certified, number one, that they needed for the employees, which was bad enough. And on the back end, they actually falsely certified that they paid the employees. So that's lie after lie after lie. And the federal government is not going to have a sense of humor about that, nor should they. So individuals along those lines will become criminal targets, I believe. Individuals that just falsely took the money and ran, not a penny went to the employees. They bought their planes, they bought their Pokemon cards. We want their Porsches back for the taxpayers as well. So it's going to be a problem, but if there's a lot of money at stake with the criminality too, we could try to understand if we could also navigate it through the False Claims Act. So I hope this was a little bit informative for you about what sort of PPP loan fraud is out there. These are just a couple. There's many other different types. If you think or suspect your employer has committed PPP loan fraud, you should speak with our whistleblower law firm by calling 877-561-0000. The call is free and confidential. We handle cases nationwide, sometimes in conjunction with local counsel, and we're only paid at the end of the day if we win your case.